Hello, welcome to Determining the Primary Aggressor. I am Jennifer Morton, and I'm glad to be with you for this training. As you can see from my background, I am an attorney and was a prosecutor for about 20 years. For 16 of those years, I specialized in prosecuting domestic violence cases. I was tasked with starting our domestic violence unit in my county, and I was very fortunate during my career to be trained by some of the best in the field. And among those were two people who you may be familiar with. Dave Sargent, who worked with the Maryland Network Against Domestic Violence in developing the lethality assessment program, and Dave Thomas, who at that time was with the Johns Hopkins University Division of Public Safety. Both were instrumental in the development of primary aggressor training when we all first got back together back in 2009 to talk about it, and I always like to acknowledge their input and vision. I suspect you are watching this because you already recognize that identifying the primary aggressor in intimate partner violence cases is challenging. Most of these cases really are a he said, she said. And we're going to see when it comes to same sex partners, it is even more challenging to sort out. Most events occur in the privacy of the couple's home, and usually there are no other witnesses, or there may be children too small to testify or safety concerns with using the children as a witness. Oftentimes, we are left with two conflicting stories, and both may have injuries. How are we supposed to sort it all out and determine who is the true offender and who is the person in need of aid and protection from domestic violence? You may also hear this referred to as the predominant aggressor. For our purposes, the terms are interchangeable, but note that the Maryland Statute Criminal Procedure Section 2-204 uses the term primary aggressor. There are three key takeaways from this training or questions that you will leave with the answers to. First, why do we have this problem in intimate partner violence cases? Second, why do we care about this problem in intimate partner violence cases? And third, what can we do about it? Because I'm an attorney, I have to include a disclaimer. I wish I could tell you that I have the magic solution for you to this very difficult problem. However, I do not. There is no magic solution. Every case, every couple, every relationship is unique, and domestic violence cases are very complex and challenging. It is not a one-size-fits-all resolution. But hopefully, by the end of this training, your perspective on these situations will have changed, and you will have some tools to help you sort out who the primary aggressor is when faced with a situation where both parties claim to have been assaulted by the other, or even try to convince us that there has been no assault at all. So, the agenda for our training, what we are going to cover, we're going to begin with a reminder about the definition of domestic violence. That is an important starting point in sorting it all out. We'll discuss what the research tells us about the scope of the problem when it comes to dual arrest. And we'll review the law in this area and with respect to self-defense. Finally, I'll give you some tools that you can use to assist you with determining the primary or predominant aggressor. These are just a few of the common themes we hear in domestic violence cases. They hit me too. They attacked me first. I was just trying to get them off of me. I'm sure there are others that you have heard as well. It's not uncommon when law enforcement officers respond to the scene of a domestic violence incident to be told this. It's a pretty regular type of scenario that they face. So let's start by looking at a case study of a fairly routine situation that law enforcement encounters when they arrive to the aftermath of a domestic violence event. We are going to look at this from a law enforcement perspective, but what we are discussing applies in all contexts, whether you're a law enforcement officer, an advocate, prosecutor, whatever your role, and when you're faced with trying to sort out one of these situations. So, who's abusing whom? Well, sometimes it's hard to tell. The facts of our case are that late one summer evening, police go to a residence in a small neighborhood for a report of a domestic. When they arrive, a male answers the door with a female standing behind him. The male asks, "How can I help you, officers?" The officers request the female to step outside and speak with her first. The officers can smell a strong odor of alcoholic beverage coming from her, indicating that she has been drinking. And the officer sees that she has some blood on the front of her shirt and around her shirt collar. She appears to be out of breath, and her speech is hard to understand. She tells the officer that she and her boyfriend John were outside having a cookout in their backyard and drinking when they started arguing about her being unfaithful to him. When asked what happened during the argument, she states that nothing really happened. They were just arguing. The officers next make contact with the male. The officer can smell a moderate odor of alcoholic beverages on the male. The male has a visible wound to his forearm, which is bleeding. When asked what happened, John states that his girlfriend, Erin, was drunk and that she drinks all the time. He said that they were having a cookout in their backyard when he learned that Erin had recently been in contact with her old boyfriend. He said that the two of them started arguing about her being unfaithful to him, and that Erin got up to leave the argument and go back inside. When asked how he got the injury to his forearm, he said that because Erin was so drunk, she stumbled as she was walking back to the residence, and he tried to catch her from falling and ended up getting hurt in the process of trying to help her. The male denies ever putting his hands on Erin other than trying to keep her from falling. What, if anything, do we do in this situation? The parties report that nothing happened, so do we leave without doing anything? Do we separate the two for the night? Would you arrest anyone? If so, whom? Would you arrest the female because the male has visible injuries? Would you arrest both parties and let the prosecutor or the court sort it all out? Do we even have enough information to do anything yet? What information do you still want to know? Where do we even begin in a situation like this? The starting point to sorting things out is the definition of domestic violence. We know it is a pattern of behavior in which one person is attempting to control an intimate partner through various means. We always want to keep this definition in mind because this is what it's all about. We know we are going to get conflicting stories. We're expecting that. But we aren't going to be fooled by conflicting stories because we're going to start by looking for who's using power and control over the other. We have to start by putting the event into context. And this is very difficult because domestic violence is not static. It's not a stable one point in time event. Often, however, that is exactly what law enforcement is dealing with. They're responding to a single incident and making decisions based on the facts of that event. Yet we know domestic violence is not an isolated incident. It's a pattern of behavior. It's very dynamic. Oftentimes, there are weeks, months, or even years of incidents leading up to this one event that the police are responding to. And so we have to begin by gathering information to help us put that single event into context. And we start by looking for who might be exercising power and control over the other person. What do we know about the scope of the problem? Do we really have a problem with dual arrests and sorting out the primary aggressor in domestic violence cases? The research tells us that across the nation there has been an increase in the arrests of women as well as in dual arrests. David Herschel did a study in 2008 on dual arrest rates. Herschel examined cases from a nationwide crime reporting database called the National Incident-Based Reporting System from the year 2000 and from 19 different states. He found that dual arrest was about 2 times more likely in incidents involving intimate partner violence, as opposed to violence between two strangers. In situations where the female was the offender, officers are 3 times more likely to make a dual arrest. And this means that when we have a female offender, officers are much more likely to also arrest the male victim. Why do you think this is so? Perhaps it is a reflection of old stereotypes that males can't be the victim of domestic violence. And you can see with respect to same-sex couples, the rates are much higher. Dual arrest rates for violence involving female couples is 39 times more likely to result in a dual arrest. And for violence involving male couples, it's 53 times more likely to result in dual arrest. This is particularly concerning because these victims may find law enforcement and the courts less accessible and may be more fearful of calling law enforcement or reaching out to the courts for assistance to begin with. But again, we have to remember no matter what type of relationship it is, we are still looking for which party is exercising power and control over the other and everything that we're going to talk about. So we're not misled into further harming the true victim. Why do we have this problem of dual arrest and intimate partner violence cases? Well, one theory is that it's an unintended consequence of mandatory arrest laws. If we go back and trace the history of domestic violence in the criminal justice system, you may recall that starting out, it was seen as a private issue and not something that the police or courts should get involved with. Over time, that view changed. So by the late 80s, mid 90s, most states were passing mandatory arrest laws that require an arrest to be made when police have probable cause to believe that a domestic violence offense has been committed. So the theory is that police, under pressure to make an arrest and unable to figure out what exactly took place, arrest both parties. Unfortunately, this means that victims are being arrested in the process. In a dual arrest situation, both parties are arrested. However, the problem is, even if both parties have injuries, often one party has acted in self-defense. Why do we care about the problem of dual arrest and intimate partner violence cases? Well, we care because if one party has acted in self-defense, which we're going to learn more about in a minute, this means that the victim is being wrongfully arrested. Unfortunately, these are not situations where we can let the prosecutor or court figure it all out because the damage is already done when that arrest is made. It is very hard to unring the bell. The investigation at the scene is the most critical point in time in domestic violence cases. And some of the problems we are faced with in dual arrest cases include: first, it lessens the ability to prosecute, often causing dismissal of the case. Second, victims are being further victimized. It has a chilling effect. It decreases the chances that the victim will seek further help. And when we misidentify the victim, then the abuser may be put into services, which could then block the victim's access to those services. We know without intervention, there's likely to be an escalation of the violence and possible eventual homicide by the offender. And ultimately, the abuser wins. And no one working in this field wants to help enable an abuser to cause further harm to their victim. Let's talk about what the Maryland law has to say about this issue. Only 35 states have primary aggressor laws, and Maryland is one of those states. Maryland's primary aggressor law is found in Criminal Procedure Section 2-204, which states, if a police officer has probable cause to believe a mutual battery occurred and arrest is necessary, the police officer shall consider whether one of the persons acted in self-defense when determining whether to arrest the person whom the police officer believes to be the primary aggressor. The statute mandates that an officer make a determination whether one person acted in self-defense and that the officer arrest the person they believe to be the primary aggressor. It is great that Maryland has a primary aggressor law like 34 other states, but how effective are primary aggressor laws? Well, unfortunately, a more recent study by Herschel and McCormack in 2019 did not find that states with primary aggressor laws significantly lessen the likelihood of dual arrest, in part due to the need for more intensive training in this area in what is a very complex issue. It's believed that police may feel that they are unable to determine who the primary aggressor is due to inadequate training and the limited amount of time that they have at the scene. So, how does an officer make a determination whether one person acted in self-defense? Well, we're going to talk about the requirements in Maryland for self-defense. Check your jurisdiction's law if you're in a different state. Self-defense is an absolute defense to an assault and battery. But for self-defense to apply, all three of these factors must be present. First, the person has to actually believe that they are in immediate danger of bodily harm. Second, their belief has to be reasonable. And third, they have to use no more force than what's reasonably necessary to defend themselves in light of the threatened or actual harm. And these factors are important because oftentimes when we look at statements as to why someone used violence, what they tell us, we're going to find that a lot of times the abuser will not express fear or the other factors that are required. For example, what did the person say as to why they hit their partner? Did they indicate that they were scared, or do they seem to definitely have the upper hand? When we look at immediate danger, it means right now, that it's about to happen, not a threat over the phone or a threat that someone's going to hit someone tomorrow. In considering reasonable belief, we have to consider the size difference of the parties and their ability to inflict harm on the other. And when we talk about no more force than reasonably necessary, the law usually requires that like force meet like force. So if one party slaps the other and the other responds by strangling them, that's most likely not going to be reasonable force. Let's go back to our case study and explore it some more. Can you see any signs of one party trying to control the other? Are there any indications of one being fearful of the other? What do you see? This leads us to our final takeaway. What can we do? Well, we want to remember first that both men and women can be victims of domestic violence. And while the abuse may initially appear mutual, we also know that abusers routinely accuse their partner of being equally abusive. They're going to claim to be the victim, and they're using a pattern of coercive control. So the best practice is when it appears that a couple is mutually abusive, we want to keep assessing that situation and asking questions about the relationship to determine the pattern of power and control. It's also important to note that the primary aggressor is not who struck who first. Rather, the primary aggressor is the party who is the most significant aggressor, the party who poses the most serious threat and has the greatest ability and inclination to inflict physical injury. For example, if we have an abuser with a history of violence who backs the victim into a corner, and the victim fears that they're about to be struck by the abuser, and so they push the abuser away, is the victim the primary aggressor? The victim made the first physical contact, but does it sound like they were acting in self-defense? That they feared an immediate offensive physical contact and used no more force than what was reasonably necessary? Although the term primary aggressor may imply two aggressors, in many or most situations, the violence is being used solely by one person. Oftentimes, the other party is reacting to the violence used against them or acting in self-defense. So we have to be prepared and we have to be ready for these situations. However, it's difficult because our abuser is prepared. It's going to be a he said, she said, and there's conflicting stories. We may often have conflicting injuries, and we can even have conflicting demeanor. Complicating the problem is that victims may often act counterintuitively. They may minimize the incident, not want to see the abuser charged or get in trouble, or blame themselves. Abusers, however, tend to put all the blame on the victim. They minimize their own involvement and are quick to point the finger at their partner. Victims may be very emotional at the scene. Abusers may remain calm and composed. We want to also keep in mind that a person who is reluctant to talk or who does not want to press charges may actually be acting out of fear. It's important when interviewing the parties to try to get as much detail as possible about the event. The batterer's account is likely to be murky as they downplay their role or skip it entirely. Victims will often take responsibility for the abuse. Batterers will often portray themselves as an innocent victim. I was just trying to get them to calm down. Batterers are often demeaning of their partner. She takes a lot of medications. Their demeanor is likely to be much calmer and more confident than the victims. And batterers will also try to bond with or form a connection with the officer or interviewer. In other words, to manipulate you. Here's an example of some important questions to ask yourself as you are assessing the situation. Who is fearful of whom? Who poses the most danger to the other? Who is seeking to stop the violence? Who has the motive to lie or retaliate? Is there cooperation? Whose story makes the most sense? We have to gather as much context as possible. And some of the sources that can help us gather context are the 911 call, witness accounts, the officer's observations, and physical evidence, the prior history. Is there a prior criminal history of prior abuse? Is there a criminal history of violence towards other? Or prior history of protective orders? Prior calls for service at that address involving those parties? What's the demeanor and body language or the physical size of the parties? Does one have offensive wounds and the other have defensive wounds? Remember to look for these signs of power and control. So let's go back to our case study. What if we started trying to gather context by checking to see who made the 911 call? And what if we learned that it was a neighbor? What if we then go talk to the neighbor to see what led them to call 911? This can be challenging because sometimes neighbors are reluctant to get involved. They don't want to talk about what they have witnessed because they don't want to get in the middle of things. Neighbors may fear retaliation as well. And I would suggest that that can also say a lot about the situation that we might be dealing with. But what if the neighbor in this case tells us that they called the police because they thought the female needed help? What if they told us that they heard the two arguing in their backyard, and when they looked out their window to see what was going on, they saw the female get up and try to go back into the house when the male came up behind her and put her in a chokehold? What if they say it looked like the female bit the male's arm to get him off of her? That starts to put what we have seen so far and heard into an entirely different context, doesn't it? And although we aren't always lucky enough to have a direct eyewitness to the assault, sometimes neighbors can still help us put the dynamics of that relationship into context by relating what they have seen or heard as far as power and control by one party over the other. Now, when we look back at our facts, we can see some signs. For example, in our case facts, the male answered the door and the female was standing behind him. The male asked the officers how he can help, suggesting he's cooperative and he's going to provide help to the officers. The signs of blood on the front of the victim's shirt and around her shirt collar. The fact that she's out of breath and her speech is hard to understand, something that would be consistent with being strangled. The male tells the officers that the female is drunk and that she drinks all the time. Significantly, both parties initially omit any mention of physical contact. It is only when the male is asked about the injury to his forearm that he explains it by saying he got hurt in the process of helping the female who was so drunk that she stumbled and he had to save her. Although the male does report that the female was trying to separate herself from him. By themselves, these facts might not seem significant, but when we put them into context and with the information from the neighbor, they take on a whole different meaning. Here's a visual graphic that walks you through the process of what we just discussed. And so to wrap up what we covered and now know, we know why dual arrests and determining the primary aggressor is so critical in intimate partner violence cases. We know why we care, because we're here to help, not cause further harm to the victim. We want to get it right if we can. And we know what we can do. We can use our definition of domestic violence. We can start looking for power and control, and we can gather as much context and evidence as possible. This is the research I refer to in case you would like to take a look at it yourself. And finally, Thank you for your attention and for all that you do in your work to help and support victims and survivors of domestic violence. Here's my contact information. If you have any questions, please reach out to me and please stay safe.